Glad to be here for now. I know many of you, but not all of you. As Mr. Miller said, I've been with the City Attorney's Office for a little over 6 years now. The last 2 years I've been serving as legal counsel to the council. And they've asked me to present a few items of information to you regarding the role of the city program, the neighborhood program, and neighborhood chairs. I'm going to start off with an anecdote. But I'm going to give you a little bit of boring legal background. So, as a general principle, only state-certified law enforcement officers have the authority to direct traffic on streets. And generally that's reserved to those law enforcement officers that are employed in the jurisdiction where it's performed. Okay? Provo has, and this is an interesting piece of legal drafting, Provo has an ordinance that says if there's a private entity that is sponsoring an athletic event that has more than 20,000 people attending it, and make it where this is aimed at, right? And that entity happens to have their own state-certified law enforcement officers that works for them, then during the immediate aftermath of such an event, those law enforcement officials that are employed by the private entity and persons directly under their supervision can direct traffic on city streets. Okay, so there's the background. So a few years ago, there's a gentleman leaving a BYU sporting event. I think it's a football game. It could have been a basketball game. I'm pretty sure it's a football game. He's leaving a football game. It was a football game because it's on, I think this happened on University Avenue. There's the big parking lot there, right? So he's pulling out of the parking lot on a motorcycle, and he wants to take a left-hand turn to go south, okay, which means crossing all the lanes of traffic. There's a BYU student who's employed as a parking cadet who's standing in University Avenue, who's directing traffic, and is intentionally directing all the traffic northbound in order to prevent anyone making left-hand turns. So the northbound traffic is stopped, so there's a gap because they're stalled, they're all lined up, and there's a gap where the driveway is. And this gentleman edges his motorcycle out, and he edges it out into the northbound traffic, and she's signaling him to stop and signaling him to go to his right. And he edges out further, and she continues to signal him and tell him to stop, and verbally tells him to stop. And he continues to pull out to the point where she's actually forced to move so that he doesn't hit her with his motorcycle. He then proceeds to cross all lanes of traffic to the opposite side of University Avenue to turn southbound, whereupon he's immediately hit by a car that's coming southbound on University Avenue. So that incident is in front of the Utah Supreme Court right now because the gentleman is suing BYU for his injuries. Okay? So I tell you that story for two reasons. One, the first principle that story teaches us is no matter how right you are, you can still get sued. Right? The second reason I bring it up is because the reason it's in front of the Supreme Court right now is because BYU filed a brief saying that the suit could not be brought against BYU because it's barred by the Governmental Immunity Act because the traffic cadet is an agent of Provo City. Okay? Their legal theory is that because the traffic cadet cannot direct traffic except for this law on the Provo City books that says they can, that they're an agent of the city when they're directing traffic because that's the only reason they have authority to direct traffic. Okay? So, the second point of the story is that all of you, in your official capacities as neighborhood chairs, perform your duties subject to Provo City ordinance. Therefore, at least under the theory that BYU has postulated, and under what we believe probably is the case right now, pending the Supreme Court case, when you're acting in your official duty, in your official capacity as neighborhood chairs, you are volunteers acting on behalf of Provo City, and your actions could result in legal liability for Provo City, which is my job, right? So I wanted to make you aware of that, to make you aware of 2 points. The first one is, what is your authority to act on behalf of Provo City? Okay. So the ordinance itself, the neighborhood program is not an independent program created by the neighborhoods that the city cooperates with. It is a program created by the Municipal Council of Provo City, by Provo City ordinance. The Municipal Council is the one that created the program. They passed the ordinances that authorize your election and that impose your duties upon you. So the duties under the ordinance are interesting. It says, the purpose of organizing the city into neighborhoods is to help identify and solve local problems and needs, and to do any other thing to accomplish the goals of the neighborhood program as determined by the municipal council. So under that ordinance, it's actually the municipal council that determines what the goals of the neighborhood program are. And those goals determine essentially what your official capacity is as neighborhood chair. So what's specifically stated in the ordinance is, in the last section of the neighborhood program, talks about two specific goals that are actually put into the, not goals, but responsibilities that are put into the ordinance by the municipal council. One is to be a direct line of communication between the municipal council and the neighborhoods. So in other words, to pass information from the council to the neighborhoods and from the neighborhoods to the council. And then the second one that there's a whole section about is to hold neighborhood meetings, and it says in the ordinance that neighborhood meetings may be held at any time to discuss issues of concerns to residents of the neighborhood. So that's a pretty wide blanket authorization to hold those meetings. And then the second one is when development applications that affect the neighborhood are submitted, the neighborhood meetings are optional, actually. The way that the ordinance actually reads is community development is supposed to notify you when such a development application has been submitted. And under the ordinance, you as neighborhood chairs have 14 days to notify the city council if you intend to hold a meeting or not. Theoretically, explicitly under the statute, if you don't notify city council within 14 days of your intent to hold a meeting, then the need to hold a meeting is waived. Okay?
That notification goes to whom?
Matt Taylor or Louise George. Louise is in charge of the neighborhood programs. The statute refers frequently to the executive director of the council, which is Mr. Taylor, but Louise has been assigned responsibility on the neighborhood program. So then, once that meeting has been held, and let's see, at least 3 days before the holding of the meeting, you're also supposed to provide notice to the council office of the meeting. And then once you held the meeting, you're supposed to file a written report with the council office within 5 days. Now, it's been the custom and practice of the council when they hold council meetings to invite the neighborhood chair to come and present information from the neighborhood at those council meetings. My next comment is not meant as a criticism or of that practice or an indication that it's going to change, but I just want to make clear that that's not actually part of the statute. That's what the statute requires is simply a written report. But this goes back to the council has had this custom and practice of inviting neighborhood chairs to speak because they serve as a line of communication between the neighborhood. Now, the one word of caution there is that the intent of that communication at council meeting is to communicate on behalf of the neighborhood. So many of us have many different hats that we wear. Right? In my role, I am both the city attorney in the city attorney's office and the council attorney. Sometimes that requires me to take a little bit different role depending on who I'm speaking to. In the same way, at these council meetings, there's a difference between being a member of the neighborhood and being the neighborhood chair. As the neighborhood chair, the responsibility is to report on behalf of the neighborhood. I'll leave it at that and answer questions about that later. Or now.
I understand the concept, but in practice, sometimes it gets muddy.
Agreed.
I've been in the planning commission where I give the report of the neighborhood. The planning commissioners don't know what to do and ask me, how would you like us to solve this?
Right. Well, and I agree. That's definitely a tricky question. And my general take on that is, I'm not meaning to infer that you can't ever give your personal opinion, but that I believe that it's important for you to distinguish which role you're in, right?
Right, but they were having trouble because I'm up representing the neighborhood, and they're asking for a solution, and all I can give them is my particular point of view. I have to take that neighborhood hat off and because I can't tell them what the neighborhood would think of the solution that is maybe discussed at the moment.
And the best example that I've seen of that, and I believe I've seen you do this before, is to answer the question by saying, I held a neighborhood meeting, this is what the neighborhood said. You're asking me a question that we didn't even talk about in the neighborhood meeting. So I can't tell you as the neighborhood chair what the neighborhood thinks. Here's what I think. Right? Yes?
Sean, I think this kind of gets to fundamentals of democracy. We could govern our whole government based off of opinion polls, just whatever the popular vote is. So from that perspective, all we're doing is reporting back on what the neighborhood thinks. That's one thing. We could also view that our elected leaders are elected to be leaders. And so I don't study every issue in depth. I let someone that I trust as president, and so not only do I want them to represent my views, but also, think on my behalf and maybe propose stuff that maybe I haven't looked at.
Right.
So, and I don't know how much that reflects on neighborhood chairs. I think it's smart to say this is what the neighborhood vote was, and then these are my thoughts on how we can move forward.
That's true, and I have no problem with that. The issue is that because of the fact that your very capacity as a neighborhood chair derives from the city council creating the program, it's somewhat like, again, and I apologize for that all my analogies are lawyer analogies, but as a prosecuting attorney, when you're standing in court, you are both a representative of your client and an officer of the court, right? And so as neighborhood chair, you are both a representative of your neighborhood and an officer of the municipal council, right? You derive your authority from them. So what I'm trying to say is just that I believe that it's important when you represent yourselves to the council and to the planning commission that you be clear about in what capacity you're acting. So I don't think that it means you can't express your opinion, but it's important, I think, not to, and I don't mean this in the intentional sense, but not to accidentally mislead either the council or the planning commission by telling them something that is your personal opinion, but portraying it in a way that leads them to believe that it's the opinion of the entire neighborhood.
It's an interesting concept because I think all of us have been in situations where something will come up in the neighborhood, a meeting is called, and a handful of people from the neighborhood attend the meeting. It's very difficult to assess from that handful of people the real feel of the neighborhood.
Right. When,
the only way is to virtually go door to door, and we're not paid enough to do that. The other thing to take into account is that even when we've taken the effort and we've done our role, we pass that on to the council, and they decide whether or not to go with what the neighborhood determines anyway.
Correct.
And we see that happening frequently, and perhaps that's where the communication between the neighborhood and members of the council needs to be improved, because then everybody has a better feel for what the issues really are.
And frankly, I wasn't around when the neighborhood program was started, but frankly, I think my suspicion is that that's why the original method for communicating was through written report, because then it mirrors the planning commission, right? The council doesn't usually get to ask the members of the planning commission, well, we see your recommendation, but tell us X, Y, and Z about why you got to that. They get a written report that says this is our recommendation. And I think the original theory of the neighborhood program was that they would get a written report that says, we held a meeting, this many people showed up, this is the question we asked, this is what those people said about that question, and end of report, right? And then they evaluated that the way that they evaluated other reports. Bonnie and Ben.
It was my understanding that when you went up and presented to council or to the planning commission, they invite the neighborhood chair to give up the report. Then we sit down, then they open it up for public comment, and then at that time we can get up with our personal public comment and speak on behalf of ourselves in the public comment section so that it's not muddied in the neighborhood report section.
Certainly, that's a good way to do it because then it clearly distinguishes between the two roles, right? Ben?
And I've done that. My question relates to the council neighborhood chair relationship. And I'm going to try to genericize this situation, but I have worked pretty hard to try to get an email address list for my neighborhood. It's about 60 or 70% of the neighbors, I believe. I would love it if the city would invest in helping that, because the only way to get a broad input, quite frankly, is by doing some kind of an email request, because most people are willing to hit reply and say yes or no, whereas very few people come out to meetings, and they usually have a very proprietary agenda as they step into the meeting, and so it's difficult to decide what the pulse of the neighborhood is. Okay, at noon on a day where I happen to be unavailable to look at email, I received a request from a city council member asking me to send out a attached document about a important item by 3 o'clock. And at 5 o'clock I read that. And I said, wait a minute, you know, and then I read the document, and I didn't believe the document represented a majority opinion of the city council. I was probably wrong in that based on recent. At the time, I knew there were other city council members who had a different opinion, and the document was fairly stacked in one direction. And so I chose not to send it out and went back to the council member and said, I feel somewhat offended by the request that came. Now, I'm sorry, I'm not genericizing this enough. My point is, how do we know when an instruction from the city council is an instruction from the city council that we're obligated to act on?
Well, that's an excellent question. I think that's why the ordinance dictates that communications between the neighborhood chairs and the council office happen through council staff, right? Because
okay, so if it doesn't come from council staff,
the only exception to that would be that I would say, I would hypothesize that the council chair probably has the authority to act on behalf of the entire council, right? But otherwise, as you point out, the council is a body made up of members, and a decision is only a decision of the council when it's a decision of the majority of that body, right? So council staff, Matt and Louise, operate under the authority of the council chair and the instructions of the council as a body. And so communications from them should be, I believe, deemed to be from the council. The council chair also has the authority to direct council staff in his role as chair. But again, my take on that would be other individual council members. Now, again, let's put this into another context too, where I've been asked questions recently about about emails coming to council chairs from private third parties asking them to announce things, right?
to neighborhood chairs.
Right. Emails coming from private third parties to neighborhood chairs asking them to announce something.
Yep.
So, are you under an obligation to do that?
No.
No. Is it inappropriate for you to do so if you believe that the item you're being asked to announce is of interest to the neighborhood and is of benefit to the citizens in your neighborhood? No. Okay. But the key here is in this third party example, without getting into a lot of free speech law and First Amendment stuff, there's a difference between commercial speech and government speech, and the basic point that I wanted to make, that I had in my notes already about that, is you don't want to take something that's coming from a third-party entity and just pass it along as it comes in, because then you're essentially using your email list as a public forum for them to say whatever you want. But if you read their message and think that it's of benefit to your constituents, you can take it and put it into your own words and pass the information along to them as government speech.
Yeah.
Does that make sense?
Yeah, I garnered the email addresses in the role of neighborhood chair, where I'm supposed to even-handedly represent the feelings of the neighborhood. And, you know, the point you're talking about is real good. You know, the mayor asked me to make sure everybody knew what Google Fiber, the one-time option to sign up.
Right.
He asked that in a public meeting with a lot of us in there, okay? And then Comcast sent an email to me not a week later saying, we're having this big blowout activity on the Olympic opening, you know?
Right.
And I said, because I was wrestling with even doing what the mayor had said, I am a strong believer in the concept of let's get every house hooked up.
Right.
But as a neighborhood chair, should I be
Well, I've been asked that question.
doing that? So what happened is that really gave me a good thing. I said, there's nothing political, nothing commercial here. Let me make you aware of two things. A, Comcast is signing up, or Comcast is having a party, free, nothing's free. And Google will let you get connected for $30, which is better than free almost, but
Perfect.
you know, and so there are, but it is really an uncomfortable position because once non-governmental entities find out you have an email list of 400 interesting people in your area, you get requests like that.
Right.
You also get requests from the city to do things that I don't want to clutter people's email boxes. Every time I send out an email, I get about one response that says, please delete me from this list. And that, you know, that's understandable, and I can deal with that, but I don't, in another year, the way things are going, my email list will be me and my wife, and she may delete me, I don't know. What I'm saying is, we ought to really talk about the protocol and what we ought to expect in terms of things that we really need to communicate and things that we choose not to. In the future, thanks to what you've just said, anytime I get a request, I'm going to send it to Louise and let her tell me what to do. Thank you, Louise.
Well, I was just going to make a comment about this. I think we are establishing protocol today. We're having Brian here. But I get your email. I am on some of your email lists, like Mike Rohn, Dave Connect, Brent Hall. Every time they send out an email to their neighborhood, I see them. And if I ever see something inappropriate, I will let you know. And I've asked everybody to put me on your email list just for that very reason, to help you be efficient in what you're doing and not get yourselves into trouble. So I would ask you again, it's a little bit more work for me to go through all those emails, and I just read them quickly. But if I do see something that's concerning, then I will let you know, and then maybe you can remedy the situation.
And going back to the situation you asked, I think your concept of involving Louise and Matt is great. Going back to the original question that you asked, again, it's in some ways it's not different than the third party, right? I mean, if someone, no matter who it is, if it's a council member, if it's a private citizen, if it's a third party company, gives you information that you feel in your judgment as neighborhood chair is of interest and benefit to the residents of your neighborhood to receive, then you have the ability to pass that along using your judgment, at least until the majority of the council tells you otherwise. Right.
Or Hal can tell me directly, right?
Right. Mike.
Mr. Miller.
I'm going to ask you to render a legal opinion this morning, wearing both your hats, both as a general citizen and also as a neighborhood chair. I feel that the decision that the council made fairly recently was a bad decision for the city and doesn't represent my part of their constituency. And so I have come prepared today for those other neighborhood chairs or general citizens who share my opinion, to share with them a referendum petition to put that decision before the general population in a general election, and have brought those referendum petitions to share with others who would like to go out and collect signatures from their general constituency to see if there's enough general support in the community to do that. I felt it was appropriate to mention that to everybody here and to, if they're interested, share these with them to collect signatures. Is that an appropriate action on my part at this meeting?
Well, let's go back to what happened, right? I mean, as an
You know, it was good. I got that out and whatever, and I asked for an opinion. But thank you.
That was very.
Verbal.
So,
People don't expect me to be so.
So, Mike, in your capacity as a Provo citizen,
Yes.
you can be politically involved however you want.
Thank you.
Okay. As a neighborhood chair, that's not an agenda item on this meeting. To the extent that you're getting people up in the hall, or since you've already made your announcement or approached by people, and you're acting as in your capacity as a private citizen, you certainly have that. Okay.
Thank you.
Yes.
Mike brings up an important topic, and I don't remember, correct me if I'm wrong, if the UTA proposal has ever been brought before and discussed, and maybe it has, but before we would sign petitions and take a position on one side or the other, I think we should all have a presentation about the pros and cons of where we are right now and what it all means, what options we have, because it's got a lot of history behind it and a lot of new stuff that's come up, and I think it's very easy to be swayed by slanted news articles or anything else that's out there.
Well, Dave, let me say this. In fact, this probably needs to be a topic that I address with the council next week, and maybe have Robert address with the administration next week as well. That one of the tricky things about this area is that there are some very specific state laws about both referenda and initiatives that, because referenda and initiatives are citizen-led efforts, there are some very specific state laws that essentially prohibit the city from taking a side, even from publishing opinion papers. Okay, so there's some tricky things here that need to be worked out. Now, so let me throw that out at the beginning. And then the next thing is, and then I probably need to get back to where I was going with my presentation. But in the effort to be helpful and answer questions, let me throw this out. As I just expressed to Mike, my opinion would be that to the extent any of you are interested in the petition, you're interested as Provo citizens, not as neighborhood chairs. So to the extent that the city wants to and is able to set up some informational meetings to let people know about the issues, that's you know, I'm kind of out of the loop on that. But that's up to the administration of council to decide whether they're setting up such information meetings, and I'm sure that if they did, you'd all be invited to them. What I will throw out to the group is that while there hasn't been necessarily a presentation made to neighborhood chairs, there are hours and hours of presentations that have been made to the city council that are all available on the city website. The work session meetings are recorded, the video is recorded, the council meeting sessions are video recorded, and all of those videos are out there on the city website. Any of you can go find those and look at those and get as informed about the issues as any of the council members have had the opportunity to be.
Different topic, would you like a different topic?
That'd be great.
From time to time, it hasn't happened very often, but in my role, I frequently will go into neighborhoods and meet with residents. And sometimes that's very informal, and sometimes it's more formal. From time to time, I perhaps have offended a neighborhood chair because I'm not plugged in like the council is plugged into this, and that is not my mechanism necessarily for communicating. Would you address what's appropriate, what's not appropriate, as far as me going into neighborhoods and meeting with people outside of the neighborhood share program?
Outside of the neighborhood share program? Well, I guess off the top of my head, outside of the neighborhood share program, anything you want to do is appropriate. I mean, you represent an entirely different branch of city government, and so it's your role to represent the administration and the administration's point of view, and to, as the CEO of the city, essentially, to go out and find out what the desires of the citizens are. And frankly, the way that the ordinance is currently drafted, if they don't want to pass them on to you, you don't have access to the neighborhood program reports because you're not in that line, if that makes sense. I think Matt wanted to say something.
Oh, no.
Is that?
It does. I think
I'm just going to say, occasionally this comes up, and with a chair will ask me a question. My standard response is typically, the mayor is free to meet with whom and whoever they wish at whatever time he wishes to do so, and that's not something under the council or the neighborhood program purview. And so occasionally, yeah, we do hear reports of neighborhood chairs that upset that there's been some other type of meeting, or cottage meeting, or whatever it is, And that's typically my response. Well, you know, if we've always had an open door for the mayor to present at any neighborhood meeting. He's welcome to try and work with the chairs. Well, sorry, open door to our area council meetings. He's certainly open to work with neighborhood chairs, again, your neighborhood meeting agendas. But if he has some other alternative way of getting input, that's up to him.
And I might mention a few things that would tell the neighborhood chairs why I might do something like that. And that is as I come into your neighborhood meetings, it's your meeting. And I'm invited at your leisure. The amount of time I have is up to you. And sometimes I may want a meeting that is my meeting, where I'm conducting and I'm in charge of that meeting. And there might be various reasons, sometimes just speed. Somebody calls me in the day and wants me to meet with some of their neighbors that night. And we don't have time to do a formal process. So if that ever happens and it is of concern to you, please let me know. Because the intention is never to go around you. It's just kind of the way it is sometimes.
Well, I think I had 20 minutes and have now taken 40, and I have a 10 o'clock meeting. So in the next 2 minutes, I'm going to tell you the last things that were on my list, and then we'll probably have to answer questions later.
I was just going to add, we were going to have Brian later, but he had a conflict. And so this is a little out of order as far as the agenda. So
some of your questions maybe will be answered by Matt and Louise later as they go through things that I didn't have on my agenda. So back to this concept that I started at the very beginning of, no matter how right you are, you can still get sued. And the fact that you are, at least in some way, agents of the city. I just wanted to mention briefly that as a warning that what that means is that there is a possibility of your actions resulting in legal liability for the city. For example, there have been successful legal cases filed throughout the country where organizations, usually companies, but I don't know if this has happened to a city yet or not, but there's been a case where a company was successfully sued for sexual harassment because one of their clients was harassing the employees when the client came to the business. Okay? Even though the corporation didn't actually have any direct control over the client. The theory was that because they allowed it, that still created sexual harassment. Because they didn't tell the client they couldn't come and tell them anymore, basically. Okay? So I throw that out there. Sexual harassment would be an issue that would certainly create liability for the city. There are others without going through the list. I just wanted to throw that out there and be aware of, again, this fact that you have a hat, that when you're wearing that hat, you're acting as an agent of the city. So having said that, as a disclaimer, so that you're aware, I need to also let you know that under City Code, there is a section that says Provo City shall conduct and pay the cost of legal defense of any officer or employee of the city, and then it also goes on to say volunteers shall be indemnified by the city in any civil action which may arise from discussions, determinations, or recommendations occurring within the scope of the volunteer's duties. The next section of the code then says that the city has the ability to determine that whatever you did is not inside the scope of your duties and not defend you. Okay, so I throw that out there so that you may have some confidence about the city's support behind you when you are acting within the scope of your duties, but then as a reminder to not act outside the scope of your duties.
Going back to your basic concept there, and before you run out, a challenge that comes up every 2 years at election time is that it's okay for the mayor or the city council to express support for a particular candidate. But for some reason, it's infra dig for a neighborhood chair to do that. Why?
It's a good question. You're right. It does come up every 2 years. And it essentially comes from this. There's two things at play. One is that there's a federal law called the Hatch Act. It doesn't have anything to do with our Senator Hatch. It goes back to the 1930s or 40s, I believe. The Hatch Act prohibits federal and certain local employees from engaging in any political activity because of the fact that those employees are essentially sponsored by taxpayer funds. That act specifically exempts elected officials. So the mayor and the city council are not covered by the Hatch Act. There is a city policy and a state there's a city executive order and a state ordinance that is also relevant that forbid executive branch employees from participating in any political activity. So that only answers the part of the question about why it's okay for the mayor and the city council, right? As to the neighborhood chair, and this is a little bit of a fine line that I'm going to say.
Brian, I just think there's maybe a slight distinction on what forbidding you in wearing your employee hat.
Right.
Okay,
Yes.
so if I'm at home as a private citizen, those orders and laws may not apply.
Good point, and that's exactly right. So there's nothing, as a city employee, there's nothing that prevents me from, as Brian Jones, resident of the Grandview neighborhood, supporting a candidate or signing a
So
petition.
you could put his sign on your lawn and that's okay.
Right. Now, as a practical matter, I personally have made a decision not to do that because then I have to work with the people after they either win or after the person that I didn't put their sign on wins, right? But I could, right? But what I can't do is sign an endorsement that says, I, Brian Jones, Deputy City Attorney, support so-and-so, okay? Now, because of this distinction in federal law, the mayor and the city council can do that. That doesn't necessarily mean it's an idea, but they can do that. They're not legally prohibited from doing that. The rule imposed on the neighborhood chairs comes from the fact that they are, in fact, subordinate, for lack of a better word, to the city council. Their position, their authority derives from the city council. So in the first place, I would argue that it's a bad policy idea because, for the very reason I just said, I don't do it. Because if, as a neighborhood chair, you officially supported someone and their opponent wins, you've inherently created a problem with your line of communication with the city council when it comes to dealing with that person. But more particularly, it's because the city council's policy has been in their direction as a body to the neighborhood chairs that they not use their title. So that doesn't mean. So here's the distinction that is kind of a fine line. What I'm saying is that you should not sign a letter saying, I support candidate X, Lindsay Wiblin, neighborhood chair, I forget which neighborhood, or whichever neighborhood, Carterville neighborhood.
We invite you to come and visit us so that you know where we are.
Okay. I just found out which one you were, so I apologize. But there is nothing to prohibit you from, for instance, signing a letter that says, I, Lindsay Wiblin, citizen of Provo City, support this candidate. And by the way, part of the reason why I support them is because I have worked with the city council closely for several years, and my experience in working with them leads me to believe that this is the best candidate. Does that make sense?
Yeah.
It's the use of the official title that portrays to the average citizen that you are actually taking an official action that causes the problem. And as another anecdote, there was last year in Texas, there was a gentleman that was elected to the state legislature and caused a big furor because his campaign ads had, this was a white gentleman, a white Republican gentleman living in a predominantly black Democratic district. Okay, his campaign materials had his name on them, but did not have a picture of him, but instead had a picture of an African American family. Okay, and then at the bottom of the campaign materials it said supported by, and it contained and it had a name. The name was the same name as a prominent member of the state legislature who was African American, but that wasn't the person who had sponsored him. Instead, he had a cousin that lived in Iowa that had exactly the same name. Right? So
That's normal for Texas.
So I can send out a flyer on a Thursday with my picture and my title relating to the neighborhood, and on the Friday I can send out a flyer with my picture and my name just supporting a candidate.
Certainly.
With no... It's just
with
crazy,
the list that you have access to as the chair?
Well, so that yeah, no, that's a good point. Now again, if you have, the email list is always a problem, right? If the email list comes to you from the city, then you're responsible to use the email list for purposes that the city has approved. If the email list has been compiled by you, but you compiled it as the chair, if when you asked people for their email, you said, I'm the neighborhood chair, and I want this email so I can send you things as the neighborhood chair, then they've given it to you tacitly only to receive neighborhood chair emails. So unless you've clarified that that you can use it for other things, then you shouldn't use it. And with that, I'm way over
Yeah, I'm
time.
gonna help
so-
Brian